Section 16. The celebrated Jenks case. This man, a linen draper of London, on the popular or factious side, having been committed by the King in Council for a so-called seditious and mutinous speech in Guildhall, demanded a copy of the warrant. This was delayed a few days, but finally given, with an excuse by the keeper that before there was an order to deny it, now to give it. This manner of delaying a copy of the warrant, to acquaint the prisoner of the cause of his imprisonment, was subsequently remedied by the Habeas Corpus Act, 31 Car. 2. Jenks' offence was simply making arrangements whereby a petition might be made for a new parliament to remedy the mischiefs and grievances the people were groaning under. Jenks, in his highly dramatic examination before the King and Council, among whom was Lord Shaftesbury, above mentioned, made no attempt to deny or extenuate his offence, but in rather a presumptuous and arrogant manner endeavoured to justify the same. He applied to Chief Justice Rainsford, of the King's Bench, on the 29th of June, 1676, the next day after his commitment, for a habeas corpus, but it was refused, on the ground that it was vacation time. On the next day the like application was made, at a general seal, to Lord Chancellor Nottingham, who ordered the matter to stand over till the next seal, which he put off from the 4th to the 6th of July. The motion being renewed, Lord Coke's authority in his Institutes was pointed out, wherein he calls the Court of Chancery an officine justity, that is ever opened and never adjourned. But Lord Nottingham replied that Lord Coke was not infallible, and refused to grant the writ because it was the long vacation. Jenks made other unsuccessful attempts to regain his liberty, and endeavoured to get tried at the Westminster Quarter Sessions, but was told that it was not the usage to calendar prisoners committed by the Council. After being in prison for over 4 months, Michaelmas term drew nigh. For some unaccountable reason, the approach of term seemed to have a subduing and awe-inspiring effect upon King, Council, and judges, and as the writ of habeas corpus could be no longer delayed, the prisoner was bailed sub silentio.